Welcome to today's presentation on new and ongoing challenges with child support income withholding orders. My name is Michael Pochia, and I am the Executive Director for Enforcement Operations for the New York City's Human Resources Administration Office of Child Support Services. During this presentation, I will provide some important information and guidance regarding those what I always wanted to know but was not afraid to ask questions regarding the income withholding order process. Together, we will explore the mechanisms, procedures, and implementation of the IWO, as well as the employer and payroll service specialist's responsibilities regarding the income withholding order for both employees and independent contractors. But before we delve into the substance of the presentation, I also believe it is essential to acknowledge the importance of our partnership here today. Employers and payroll specialists play a key role in our child support program. IWOs generated on child support cases in New York ensure that nearly 1 million of our state's children have the financial support they deserve from both parents. At the end of calendar year 2022, the New York City Office of Child Support Services collected $671 million on behalf of the 198,000 cases we have with child support orders that we are enforcing. Now, as this chart shows, 71.3% of this amount is based on the income withholding order garnishment. I will also note that in calendar year 2023, this employer income withholding collection percentage returned to its historical pre-COVID level of around 74 to 75% of our child support collections. The topics you see outlined here are based in no small part on employer and payroll specialist questions received at the New York State Call Center. Today, we will cover the importance of the income withholding order, how to report new hires, understanding the Wage and Health Benefits Report, the Weber, the employer's responsibilities for the IWO, recent changes to the IWO, dealing with lump sum payments, and the newest law, our new law on independent contractors. Before getting to the nuts and bolts of the presentation, I just want to take a minute to briefly mention something I try to remind myself of every day. There are employers in the audience here today, payroll service specialists, individuals from different organizations, other stakeholders in the IWO process. All of us, we deal with paperwork, phone calls, emails. We review charts, graphs, statistics. We do calculations. We label individuals as custodial parents, non-custodial parents, employees, independent contractors. We sometimes forget that there are real people, real families impacted by what we do and what we fail to do. And each of us together affect the economic well-being of not only the children, but the parents that are involved in the process. And we must therefore strive very hard to always try to do the right thing. So with that said, let's begin. We start with the very basics here, and that is third-party agents, meaning payroll service specialists handling the payroll duties of the employer have the same responsibilities that the employers do. And employers are responsible for ensuring that their agents meet the reporting requirements and that the IWO implementation is done correctly. And those responsibilities include new hire reporting, very important first step in the employer's responsibility. Employers must report all newly hired and rehired employees within 20 days of their hire date. Now, you must also, as you've heard about the new law on independent contractors, you must also report independent contractors to new hire. The information is maintained in the National Directory of New Hires and in New York State in the quarterly wage reporting system. What happens after that reporting, what happens next, is that our state child support system, the Automated State Support Enforcement Tracking System, referred to as ASSETS, conducts matches to these databases for individuals with child support orders. And these matches result in IWOs being generated. This process is automated and reporting, and if the reporting is done correctly and on time, it helps speed up the IWO process and collecting and distribution of the child support monies. Now there are penalties involved if employers don't report within the mandated 20 days, but we're not even going to discuss that here today because I'm sure all the employers listening to this presentation will meet that 20-day mandate and help make this process go more smoothly. The information you see here is probably more of a review for you than me providing you with any new information. Employers are required to report the employee's name, address, and Social Security number. The Social Security number actually is especially relevant for our child support cases, as it helps make sure we avoid any possibility of any mistaken identity issue. In other words, sending the IWO to the wrong person. Also, you include the hire date, employer's name, address, and FEIN number. Also, you're reporting the dependent health insurance benefits if they are available. How to report. One positive outcome from the pandemic, I guess if there is one, is that because many of us worked from home, we moved more quickly to a paperless business model. Reporting methods such as reporting online electronically are way more efficient and effective. You could still fax the information, although I would argue the fax machine is quickly becoming as outdated as the pager. The mailing methods still exist as well. So there are several different reporting methods you can use. Although, again, I do want to emphasize here and throughout this presentation that doing things electronically works best for us and hopefully works best for you. So as a takeaway, push your organizations, your payrolls, human resources administrations to work towards electronic filing. And that's my public service announcement part of today's presentation. The Weber. Your company may also receive a wage and health benefit report in the mail. You're receiving this form because child support is seeking earnings and benefit information for the employee. Now, this document is separate from the IWO that we'll talk about soon, but it's just as important. In the past, New York State would send the Weber in practically every case. Not so much anymore. New York City normally only uses the Weber for employees and independent contractors when we are seeking to modify their order or implement a cost of living adjustment, a COLA. This information helps make sure that the non-custodial parents, this employee's order, is in line with their income and what they can pay and what they should be paying. Now we get to the income withholding order. 4 pages of huge impact. Our best friend. The income withholding order is understandably a major component of today's presentation. We will dissect these 4 pages and the critical information contained within this order. The official title of the order is the Income Withholding for Support. Now, this IWO, this income withholding order, is considered an order if it comes from a 4D child support program like ours, or when it comes from the court. It is considered a notice if it's sent to you by an attorney, a tribal legal representative, a private collection agency, or by a non-custodial parent or custodial parent. The IWO indicates on the order which person or entity it's coming from. If the IWO is a notice, Payroll cannot implement the IWO unless the court order is attached. If the IWO falls under this order designation, the order itself is not needed and you can implement the IWO without the order. Further, all payments made through the IWO must go through the support distribution unit. If the payments are not directed to be paid through the SDU, the IWO should be returned to the sender. It is not a valid IWO if it's not made payable to the support distribution unit. Critical points to remember. First and foremost, there should be no and there is no stigma associated with receiving an income withholding order for any employee or independent contractor. It is not an indication that the employee did anything wrong or is unwilling to pay. In each case, when an employer is identified through a new hire match, an automated process takes place where the IWO is systematically generated and sent to the employer. Now, some of you may remember in the past, actually prior to 1996, New York's IWOs were based on default. In other words, the IWO would only be sent if the non-custodial parent wasn't paying on time. This is not the case anymore. It is actually a benefit for the non-custodial parents and the custodial parent that the income withholding order is implemented on as many cases as possible. In New York State, an employer cannot charge a fee for implementing an income withholding order. Employers must comply with the income withholding order and may not discriminate against an employee in any way because of child support deductions. In New York, it's actually a crime, and there are civil penalties if an employer lays off somebody, fires somebody, disciplines somebody, or refuses to hire an employee because of the existence of an IWO. Also, an employee can't show up at your office and say, I don't want this income withholding order. I want to pay by myself. Payments by income withholding order are mandatory. The only exceptions from this mandate is if the employee articulates to a court a good cause exception from the implementation of the IWO, or if the two parents work out a deal at the beginning of the case. In these instances, you wouldn't have received the IWO, so it wouldn't matter. Other than these two exceptions, once a valid IWO is received, the employer must honor it, even if the employee tells you it's okay, I'll pay on my own. Again, you must comply with the income withholding order. It is an order. Paying by income withholding order also prevents the employee from becoming subject to certain of our administrative enforcement processes if they become behind in their child support payments. The employee will not enter the driver's license suspension process. And of course, many employees need their licenses for work. Employees' bank accounts may not be restrained if the employee is making regular IWO payments. So again, the income withholding order, in every sense of the word, is critically important to the case from both an enforcement point of view and from a collection and payments to the custodial parent. Determining what income should be withheld. When I was in law school, my tax professor once said, and I still remember to this day, everything is income unless something or someone tells you otherwise. And that's very true in New York. And you probably all know this already after reviewing your own tax returns. Income is defined under New York law. There is no federal definition for income. New York State defines it in its New York State Civil Practice Laws and Rules, the CPLR. And income, my goodness, is just about everything. It's salary, it's periodic and lump statements, payments, its wages, its workers' compensation, disability benefits, pensions, retirement, Social Security, commissions, bonuses. Perhaps the only two exceptions what are not counted as income is cash assistance and supplemental security income. And working individuals, employees, independent contractors probably wouldn't be receiving either of these benefits. So except for those two bullet points, cash assistance and SSI benefits, everything else you see on this slide is income and subject to an income withholding order. With the IWO, it's not just the who, what, or where. It's the who, why, what happens, when, how much, how often, how to pay. So the employer needs to check the type and source of the IWO. Confirm the employer and employee information. It's important that the employer notify child support if the employee is terminated or may never have worked for you. Check the date the IWO was issued. Review the order information and the amount to withhold. Confirm the amount of disposable income to withhold under the Consumer Credit Protection Act, which we'll talk about later. But for now, let's say this. It's important to review the CCA limitations because there's an obligation amount in a court order and there's an amount that has to be deducted from the employee's wages shown on the income withholding order. Yet it's also critical that the non-custodial parent isn't left without the financial resources to live and to care for their own basic needs. And finally, the employer needs to know how to submit these payments. Checking the type and source of the IWO. In reviewing the IWO, the employer needs to check the type and source of the IWO. At the top of the IWO seen here, and this is on page 1 of the IWO, there are those 4 boxes, 4 IWO types. You might be receiving an income withholding order for a new child support order. You could be receiving an amended income withholding order based on some change of circumstance that occurred in the case. Maybe the non-custodial parent no longer owes arrears, for instance. It might be for a lump sum payment. It might also be a termination income withholding order. Perhaps the children in the case are now emancipated and the employee doesn't owe any arrears. Maybe the employee doesn't work for you any longer, and we've located that information, and we send you the termination IWO. You also want to check the source of the income withholding order. Again, as I stated earlier, it could come from a child support enforcement agency. It could come from the court, and those IWOs would be considered orders. It could come from an attorney. It could come from a private individual, thereby making it a notice, in which case you need to not only receive the IWO, but the underlying court order. The IWO must be regular on its face, which basically means that any person looking at it would think it's valid. Certain things to consider if it's regular on its face. You want to check to make sure that the IWO is payable to a support disbursement unit. You want to make sure that the underlying order is attached if the IWO is deemed a notice. You want to make sure that the income withholding order is in United States dollars. You want to make sure that there is no changed language or any other alterations to the document. If there is, you should notify us immediately. You should send it back. It's not to be honored if any of those issues outlined are present, and therefore making it non-regular. Confirm the key details of the income withholding order. You need to confirm the identifying information for the employer and the employee. The employer's name, employer's address. Again, this review, really important. Child support wants to make sure that the IWO is being sent to the right location. When an employer notifies the Department of Labor through new hire reporting, the address the employer provides is not always the same as the payroll office address. Again, especially if there's separate offices for workers' compensation claims and for payroll administration, where the IWO is likely to be processed. If the employer were to respond to child support and provide the payroll address, well, we can build an employer record. So future IWOs go to the correct payroll location, not only for this instant case, but for all other employees of the company, because we can update our records and correspond the records to other employees going forward. Next, check the employee's Social Security number and date of birth. This information helps us prevent any mistaken identity claims that might arise. While it's important to garnish the employee correctly, the last thing we want to do is wage garnish an employee that should not be garnished. Reviewing and checking this critical information is important to make sure that this process goes smoothly and efficiently. While the vast majority of IWOs are based on an automated data match with new hire information, there are times where a third party, maybe it's a custodial parent, contacts child support and provides information that the non-custodial parent is employed at XYZ Corporation. And this information we receive is not always accurate. However, based on that information, as it's known to us at the time, an employer record will be built and the income withholding will be sent to the employer. Again, child support would not know at this point if the non-custodial parent actually works at the company. Under these circumstances, again, it's critical for you to let us know if this person doesn't work for your company or no longer works for your company. Filling out and returning the Notice of Employment Termination located on page 4 of the IWO helps us to update our employment records and helps prevent you receiving those non-compliance notices, alerting you that we haven't received IWO payments. It also negates those follow-up calls from my staff when we haven't heard from you. So again, this makes the process go more smoothly and efficiently, and for you not to be distracted with those multiple child support correspondence and phone calls. It is also super helpful if you let us know not only if an employee is terminated or it doesn't work for you any longer, but provide where the former employee is now working, if you know. We can act on that information and make sure that an income withholding order is sent to the new employer and avoid gaps in payments that would be going to the custodial parent and the child. When to start withholding. An employer must begin wage withholding no later than the first pay period that occurs 14 days after the date of service of the income withholding order. An employer or payroll service must then remit these payments to the New York State Child Support Processing Center within 7 days of the pay date. Not withholding or remitting could result in penalties to the employer. However, we know that all employers and payroll services listening to this presentation today are already doing that and doing what's supposed to be done. So again, we don't even need to talk about penalties. But again, they do exist. Listen, following these rules is so important because it benefits the children and the parents. The money is received and will be dispersed at the earliest possible time to the families. When to start withholding, this example. Suppose the date of the income withholding order is October 31st, 2018. However, the first pay date after the receipt of the IWO in your company's payroll cycle is November 2nd. You understand you have 14 days after the date of service of the IWO to begin wage withholding. However, the turnaround time from the 31st to the 2nd is too quick to act, and your next payroll would be after 14 days. You at this point don't have the time to implement the IWO and can't finish the processing between the 31st and the 2nd. That's fine. It's fine to implement this IWO on the subsequent payroll. So where the 2nd would be too early and the 16th is technically past the 14 days, this is still going to work. And the IWO police are not going to come to your agency and say you're 2 days over or anything. It's acceptable. It's acceptable to do it that way. Determining the amount and frequency. In reviewing the income withholding order, you will see the amount to withhold for the employee or the independent contractor. In a child support order from the court, a judge or support magistrate will determine a frequency for the payments. The order could say weekly, bi-weekly, or even monthly. However, employers can remit payments based upon your payroll frequency. That is why when you receive an IWO, such as this example here, it's going to show the amount to withhold on a weekly, bi-weekly, monthly frequency so you can match it to your payroll. In this particular example, you'll see that the current child support is $150 bi-weekly, and you see a $75 past due support. This $75 addition is what's called the add amount in the income withholding order. If the non-custodial parent owes arrears, past due child support, you will see a wage garnishment amount being added on the same line of the IWO next to the check boxes for the arrears greater than 12 weeks. This 12 weeks information is going to be needed by you to calculate CCPA limitations, which we'll talk about later. Keep in mind that this $271.92 biweekly number may actually be an amount that's too much for an employee, non-custodial parent to pay based on their salary and disposable income. Child support certainly doesn't want to leave the non-custodial parent without the means to meet their needs as much as possible. We don't want to leave your employee, the non-custodial parent, in despair with a sense of hopelessness. So there are safeguards that exist in the form of calculating CCPA limitations. The add amount is an administrative garnishment amount that's added to the obligation amount that was set by the court. As you saw in the last slide, the $75 example we spoke about. The add amount is requested when there are child support arrears, past amount due owed by the employee. That's why you might see a past due amount in the IWO. And it's also the reason why an employee may go to your payroll and say, my court order is $150. Why am I paying this additional $75? It's not for the employer or payroll services to make the determination of whether or not the add amount should be included or not. If the employee says that they can't afford the add amount, the employer should encourage the employee to contact child support and request what's called an add amount review, or it's sometimes called a hardship review. The employee could request this review by emailing the New York City Child Support at the email provided on the screen here. They could visit our customer service center at 151 West Broadway in Manhattan, or they could mail the request to P.O. Box 830, Canal Street Station. The purpose of the add amount is to ensure that the purpose of the add amount review is to ensure that this additional payment doesn't bring the non-custodial parent employee below the self-support reserve. And in New York in 2022, this amount is $18,347. If the add amount does bring it below the self-support reserve, child support can reduce or even remove the add amount. Again, this part of the administrative enforcement process is done by child support. The employer does not make the determination. The employer is just following what they see on the IWO. But as I said, it's beneficial if the employer does let the employee know if there is such an issue does exist, how to contact us, and they should contact us. Contact us. Checking the CCPA limitations. One of the major responsibilities of an employer in this IWO process is to confirm that the amount of wages withheld from the employee does not exceed the Consumer Credit Protection Act CCPA limitations. And this limits the maximum amount of wage income from an employee's disposable income that can be withheld for child support payments. These limitations apply for personal services income, which is salaries, commissions, severance pay, lump sum payments. CCPA limitations do not apply, and no calculation is needed to be done if the income compensation is not from personal services. And this is income from dividends, interest payments, and other benefits. Only the employer really has the ability to calculate CCPA, the CCPA, because you know the employee's gross income and you are in the best position to determine the employee's disposable income. And disposable income is the amount of wages left after the employee's deductions for federal, state, and local taxes, as well as Social Security and Medicaid deductions. The employer's responsibility is to make these calculations when appropriate. Now, if an employer is not sure of the procedure, if it's the first time you ever heard the term CCPA limitations, by all means, please contact the Customer Services Helpline for New York State or contact Customer Services for New York City Child Support. Our staffs will be more than happy to walk you through the process. What are these CCPA calculations? What are these percentages? Well, it actually depends on the date of the income withholding order. The calculations and withholding order are different if the income withholding order is dated before August 29th, 2018. The federal government made changes to the CCPA calculations and percentages for IWOs after August 29, 2018 to simplify the process. If the IWO is dated after August 29th, 2018, the only question is whether the employee has qualified arrears. And the employer knows if the employee has these arrears because the IWO tells you they have the arrears. That box that says arrears greater than 12 weeks, if that box is checked in the income withholding order. If there are no arrears, the box is checked no, the calculation for disposable is 50% of disposable income. If there are arrears, the calculation is 55% of the disposable income. If the income withholding order is dated prior to August 29th, 2018, the employer must know not only if there are qualifying arrears, but also whether or not the employee has another child support case. And the percentages in this calculation would be 50, 55, 60, or 65%, depending on which circumstances exist. And I'll show you a chart in a few minutes that will explain what I'm talking about here. Making the smooth transition to this new calculation. So here's how it works. If the IWO is dated prior to August 29, 2018, it is governed by the former rules. The four possible percentages, 50, 55, 60, or 65. If a new IWO comes in for this employee and the employee does have a prior income withholding order prior to August 29, 2018, you're going to recalculate the whole case based on the new rules, 50 or 55%. This chart here, hopefully conveys what I've been trying to articulate. If we go back prior to August 29th, there were 4 different possible percentages to calculate against the employee's disposable income. If the employee supports a second family or the arrears and the arrears are less than 12 weeks old, 12 weeks, the calculation would be 50% of the disposable income. If they support a second family and there were arrears more than 12 weeks, the percentage goes up to 55%. If there's only one family and no arrears, the disposable income percentage would be 60%. And finally, if there was a single family and there were no arrears, we're up to 65% in the calculation of the disposable income. Now, for all orders after October 29, 2018, again, only 2 possible percentages to use in calculations. It's 50% if there were no arrears on the case, and it's 55% if there were arrears over 12 weeks. Again, if that checkbox is marked yes. And again, very important because we don't want to leave the non-custodial parent without wages for their own basic needs. We want to balance the needs of the different individuals involved here for all the families involved, the employee and the employee, non-custodial parent, and the custodial parent or custodial parents. Priority of withholding. After calculating these percentages of an employee's disposable income that could be wage garnished under CCPA limitations, well, there may actually be not enough income garnishment to meet the entire court order obligation amount for this employee. And when the income withholding amount exceeds the maximum withholding for the employee or independent contractor, the employer must prioritize the withholding in this following order. It's the current support obligation gets paid first, then court-ordered health insurance, premiums, and then past due. The employee can't come to you and say, I want to pay this amount or that amount. The employee can't dictate the amount to be paid or the frequency. It is the responsibility of the employer to follow these priority withholdings. Under this reasoning, I guess if an employee tells you, I don't have a child support obligation, my obligation's terminated, here I have a court order saying so. No, the employer has to honor the income withholding order unless instructed differently by child support sending another withholding order, amending or terminating the prior IWO. Clearly, if any of these issues arise, or the employer has any of this documentation, or sees any possibility of any of these issues existing, the employer should call child support or strongly encourage the employee to do so, so we can resolve the issues, so we can investigate the problems. Priority withholding when there are multiple IWOs. An employee may be responsible for child support payments to more than one family. And when it comes to withholding orders on multiple cases, multiple IWOs, again, there may not be enough wage withholding to cover all the employee's obligations on all the orders. In this instance, the employer must withhold payments on each order for current support to the greatest extent possible on a prorated basis. That's New York's method and the method used in most other states. The other methods that some states use is the equal method. In the prorated method, the employer reviews the multiple IWOs and the total obligation payment per month the non-custodial parent is obligated to pay. Let's say the amount is $200 on combining the two income withholding orders. One order, the obligation amount is $150. The other one is $50. However, that total amount that can be collected from the employee or the non-custodial parent, the total amount that could be collected, say, is $100. In this prorated method, you would take the total amount the employee is obligated to pay and the percentage of that amount owed to each family. That will determine how much of the $100 goes, which percentage goes on each income withholding order. You can't just say, okay, $50 for one IWO and $50 on the other. That would be under the equal method, and that's not how New York operates. Again, the employee can't say to you, I want to pay only this IWO this month and then this IWO next month. Or I just want to pay this one IWO because, well, I like this family better. Your payroll office can't decide and should not decide to alternate between income withholding orders on a payroll cycle. Remitting payments. Hopefully, again, if there's anything positive, as we said earlier, from working remote and being effective, as we become more of a paperless society, and we could do more things remotely, internet. Here, for remitting payments, I want to stress again the importance and effectiveness of remitting payments through electronic funds transfer or expertpay.com website, which are great ways for an employer making the payments without paper, without sending a check. These methods will result in less errors and less cost to the employer. You don't need to submit those coupons. It's quicker, it's easier, it's a more secure way of making these payments. There is a one-time setup. You enter the employee data once, you don't have to re-enter it again. If you want to know more about these methods, I would strongly encourage you at the end of the presentation to call the employer helpline for any other information that you might need, that you might want to hear to get this done. You can go on the expertpay.com website and take a look at it for yourself to see how the platform works and learn more about the process. Again, doing things automated, doing things electronically is much more efficient and a much more efficient way for us to operate, and it's a win-win for your organization and our organization. For those of you not yet interested in the electronic method, you can still remit by check. One of the most common questions asked by employers is, can they submit all income withholding, wage holding employees on one check? Well, the answer is yes. You could send child support the processing center one check. However, you must put the identifying information for each employee on the check or attach a document to the check with that information, the date of the withholding, the case IDs for each employee, the amount taken withheld for each employee. So it's all clear to the processing center to make sure the right money goes to the right case. Again, let me say it again. It's much easier to do this electronically, so we don't have you don't have to write those burdensome checks each month. Seriously, consider it. We're here to help you if there's any questions involved in the setup. Doing it, again, because it's a win-win for both of us. Lump sum. These lump sums are probably the most misunderstood wage withholdings in the world of employer and independent contractor IWOs. Lump sum collections are included in the income withholding process. However, lump sum collections are applied towards past due child support, the arrears. So the process is a little bit different. There is a procedure in place, which we'll talk about in a minute, to report lump sums to the New York State child support. In each case where you have a lump sum payment, you should reach out to the state to make sure you're withholding the required amount of the lump sum. The withholding is not the same as the weekly child support obligation that you might be garnishing on the IWO. Not at all. So if the non-custodial parent, say, pays $100 a week in child support, and that employee is now getting a $1,000 lump sum payment, the process is not you withhold the usual $100. The rules for the lump sum are different. In the lump sum circumstance, you should contact the New York State Child Support, as we're about to discuss, and New York State Child Support will be able to tell you how much should be withheld. There are many different examples of lump sum payments. This list is by no means exhaustive, but they are the most common ones and the ones employers most frequently ask about. Lump sum payments could include bonuses, retirement, 1099 income, commissions, workers' compensation, Social Security, severance payments, insurance settlements, personal injury settlements, stock options, dividends, and leave payments, payouts. For lump sum payments, again, the best approach, the surest way that things are being done correctly is to contact New York State Child Support at the email displayed on this slide or to call the number on the slide. A child support representative will ask you for information, which I will show you soon, and explain how much has to be garnished based on the type of lump sum payment or whether or not CCPA limitations apply. The lump sum reporting process. First, again, contact the support distribution unit, the disbursement unit, to determine whether or not there is past due child support owed by the employee, and if so, how much. If there's no past due child support owed, the SDU will tell you that 100% of the lump sum payment will go to the non-custodial parent. If there is past due child support owed, the next question is whether the lump sum is for personal services. If it is for personal services, then CCPA limitations and that 50 or 55% calculation needs to be done. So if the lump sum payment is $1,000 and it's for personal services, then child support would, the CCPA limitations would subject that amount to either 50 or 55% of the disposable income. If it's not for personal services, that lump sum payment, like for dividend payments, then CCPA limitations do not apply, and the amount that could be garnished, the amount to be garnished can be 100% of that lump sum payment. Again, lump sum payments and CCPA limitations. Again, as I mentioned, CCPA limitations for personal services versus non-personal services. If the payment for that lump sum is a commission, if it's a severance, if it's a leave payout, if it's a bonus, those CCPA limitations are 50 to 55%. Those are the percentages that would apply. If the payment is for a dividend, an interest payment, another benefit, CCPA limitations would not apply. And again, it's important to recognize that 100% of the garnishment is on the table. So that's a significant difference from what we said earlier, $100 weekly, and the percentages of the 50% of $100. I'm sorry, of that, or the lump sum payment, which is a significantly higher amount, and which the 50 or 55% percentage is going to be based off of. What to report? The information you need is right here. Any questions, contact the New York State Child Support. Provide your company name, address, phone number, email address, the amount of the lump sum, the expected date of the distribution. The New York State Helpline will assist in determining the right amount that needs to be paid. Yes, the independent contractors. As you heard today, the new legislation in New York makes employers responsible for garnishing independent contractors just as if they would with employees. And if you receive an income withholding order for an independent contractor, You must follow the income withholding order and wage withhold just like you would be doing for employees. Independent contractors' salaries, lump sum payments, they must be garnished. One further thing we must discuss today is the EIWO, the electronic filing of income withholding orders. The process is free, paperless, it's cost-effective, it's an efficient way to electronically exchange income withholding information without paperwork, without documents getting lost in the mail, without documents going to an incorrect address for processing, without any follow-up to employers for noncompliance, those phone calls that then we know how much you like and how much we like making, because you're getting the income withholding order electronically sent to you. And there are two options here for your business. First, there is the no programming option for those organizations that have limited technology resources. The second is a system which is fully automated and which updates employee information. Included on this slide is the website and contact email to learn more about the EIWO process. Everybody from child support would strongly encourage you to review the advantages of the EIWO. Again, utilizing it is a win-win for both of us. And again, I think it's worth your time to check out the link for the EIWO and see if it'll work for your company. And finally, here are some contacts if you have any questions going forward. This presentation is ending, but our relationship continues. Keep in mind that more information on the topics we discussed today, the income withholding orders, the MEDEX, the calculators, they're found on the New York State and New York City child support websites for your viewing pleasure. Now, these conferences are normally held twice a year, and in between these larger conferences, New York City Child Support holds question and answer office hour sessions, which employers can sign up for time slots to speak directly to child support professionals to help answer specific employee case questions or other IWO questions you may have. So be on the lookout for announcements containing these future office hour dates so you can sign up and take advantage of the opportunity. And of course, New York State and New York City customer services stand ready to answer any of your further questions and to foster this partnership and to work together for the benefit of both your organization and ours. Thank you very much for your time today. It was very much appreciated.